Hi, this is week 4. We're going to be looking at chapter 4 in LE 101. The topic for these 2 weeks, weeks 3 and 4, is chapter 4. So hopefully everybody has read that by now. And we're talking about the American legal system, which is the foundation of everything that we are talking about in this program. Having a clear understanding of how our government works and how it operates is going to be crucial to your success in the legal field, obviously. Okay, so branches of government. There are 3 branches, and before we even get to that, let's review the concept of federalism. The U.S. government is a federalist government, meaning that it divides power between one national or federal government, so the President, the United States Congress, and the United States Supreme Court and lower courts on the federal side. And then we have state government and D.C. And each state can set up its own government how it wants, and then power is split between the two. If you remember historically how we got there, we started with the Articles of Confederation, which didn't work. It was a very strong state-centered system in which the states had the majority of the power and the federal government was a very small portion of everything. But without having that kind of broad, bigger umbrella over the country wasn't really functioning because, all sorts of problems happened. States were coining their own money, so then you would cross the state border and you couldn't use money there. There was no protection set up for if anybody was trying to rob or loot or anything across borders. We didn't have a cohesive military. We didn't have a cohesive monetary system. Travel was difficult. Everybody wasn't cooperating as I think the original intention was. So we ended up with the Constitutional Convention to try to fix that, and the United States Constitution was assigned and put into effect, and then we have what we have today. And the United States Constitution is really a product of great compromise. There were proponents of strong state rights and there were proponents of a strong national government. Those of state rights didn't want to have a king again. They didn't want to have somebody controlling them that was a far distance away, like they ended up with when they immigrated to the United States, and then there was the King of England trying to control everything that they were doing. And they wanted to avoid that. So you also have to remember that this is the 1700s, and the means of travel and communication were much different than what they are today. And then we have the other side that favored a stronger national government, just for avoiding the problems that have been faced so far. So the compromise was the U.S. Constitution that we have today that divides the power between 3 branches in the federal government and then power to the states. The 10th Amendment is the big one there. All powers not specifically delegated to the United States of America or to the U.S. government are specifically reserved to the states. So anything that the Constitution does not give specific power to the U.S. government to do, the national government to do, is reserved to the states. So we ended up with that division first. And then next we have the division of power within the federal government, the 3 branches, which we've talked about: the executive branch, which is the president and all the administrative agencies that follow underneath of there; the judicial branch, which is the United States Supreme Court. Article 3 of the Constitution establishes one U.S. Supreme Court and all inferior courts as needed that the legislature wants to establish underneath of that; and then the legislative branch, which is the U.S. Congress. Okay, so here are the concept of separation of powers, checks and balances. These are all to try to avoid that king, again, to try to avoid a concentration of power. So we have the legislative branch, which makes the law, and that's the United States Congress, which is a bicameral legislature, and it's divided between the United States Senate and the United States House of Representatives. And here's one of those compromises. As you know, all the states are different sizes and different populations, and some states are really big but have a small population. Some states are really small but have a really big population. So there was this discussion and debate on how much representation should be put into the United States Congress based on each state, because it doesn't make sense to give the exact same number of representatives to a really small state that it does to a really large state when the populations are so different, but then it also doesn't seem fair to give one state more power over another by virtue of size. So the compromise was the United States Congress that we have today that has the U.S. Senate, and each state sends 2 representatives, 2 senators that serve 6-year terms. And then on the flip side, you have the United States House of Representatives, which those representatives are based upon population and serve 2-year terms. We have 435 members, and it depends on what state you are in as to how many representatives you have. For instance, West Virginia has 3, whereas California has many more. So that was one compromise. So Article 1 established the legislative branch that makes the law, the statutes. The executive branch enforces the law, and Article 2 created it, and the judicial branch was created in Article 3, and it interprets the law. And then, as I mentioned, the 10th Amendment there. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So anything that the United States government is not specifically given power to do is reserved or left to the states to do. Okay. The United States follows what is called the common law tradition. It's a body of law that derives from judicial decisions rather than from statutes or constitutions. So if we look back to like English common law, and historically, where the law came from, it was based on those decisions made by the judges, and they set what was called precedent. Or whenever they made a ruling and you had a final case, that case was then to be relied upon in future decisions so that there was a reliability to the law, an expectation of what the law was. And that policy of following previous decided cases or following precedent is called stare decisis. So this was the tradition of following judge-made law versus statutory law. Now statutory law dominates our legal system much more than it ever did before, but we still do have judge-made law as well, interpreting the statutes, because there can be so many nuances to each statute and different facts that exist that they all work together now. Okay, so the 4 sources of law, we have Constitution. So we have the United States Constitution, which is the supreme law of the land, and then each state has its own constitution as well, setting up how its government is going to work. Then we have statutes created by the legislative branch. Always be careful when you're typing out statutes or referring to statutes. It's a tricky word because if you miss that T or replace it, you can get stature very easy. You can get statues very easy. So make sure your spell check's not going to find that. So make sure that you pay attention when you're typing it. Then we have administrative regulations, and that comes from the executive branch. So the executive branch is charged with enforcing the law. So when a statute is handed down and it affects something like the environment, then the United States Environmental Protection Agency will have that statute and can enact rules and regulations to further explain what that means. So maybe they're only allowed to have so much pollution in the water source, then the EPA can go through and write rules and regulations for determining how that will be determined and what that specifically means, and etc. And then case law or judicial opinions, which are the decisions of the judicial branch interpreting application of those statutes to, or those regulations to specific facts, specific cases. Okay, 2 words you're going to see a lot are jurisdiction and, venue you won't see as much, but it will pop up. Venue is merely the location where something happens, where the case is going to be heard. In West Virginia, there are multiple circuits. Parkersburg falls into the 4th Judicial Circuit, which is part of Wood and Wirt counties. And so say that you have a case that takes place there or in a neighboring county like Ritchie County. One example that comes to mind, in Ritchie County many years ago, there was I think he was a part-time school bus driver, and he also worked as a lifeguard at the community pool during the summer, and he was accused of molesting like 100 kids, something crazy like that. So obviously you have a very inflamed and upset community. So when those charges were brought and he was brought to trial, his counsel made a request for a change of venue because the odds of getting a jury in Ritchie County that were not affected by this situation were very slim. So they did a change of venue and moved it to the 4th Judicial Circuit, where it was heard in Wood County. So venue is that location where something happens. Sometimes a change of venue can occur if it's needed to ensure a fair and just trial. Now, jurisdiction is a much bigger word, and it has a lot of different nuances, a lot of different parts that come about with it. Subject matter jurisdiction, it's discussed in pages 85 to 87 in your text, and this is the big one. This is making sure that the court has the power to hear the case that they're talking about. Now, when you're in federal court, remember that 10th Amendment, anything not specifically given to the federal government is reserved to the states. So in order to file a case in federal court, you have to have federal jurisdiction. There are two ways you can get that. The first is federal question jurisdiction. So that means that you have a question arising under the U.S. Constitution or under federal law. So you have a question dealing with a federal law, one of the specific areas left to it. So you can file your case in federal court if you have a federal question. The other way is diversity jurisdiction. So this is when you have a party from one state suing a party in another state. So there's not a clear decision on which state, would be best to file the case in. So you have to have parties that are completely diverse from one another, meaning that everybody on one side, all the plaintiffs have to be from different states than all the defendants. If anybody is from the same, so say you have plaintiffs A, B, and C suing defendants E, D, and F. If plaintiff C is from Massachusetts and defendant F is from Massachusetts, then your diversity is ruined and you don't have complete diversity. You have to have complete diversity, and you also have to have more than $75,000 in dispute. So it can't be $75,000 flat, it has to be at least $75,000 and a penny in order to file under diversity jurisdiction. Okay, some other jurisdiction terminology. Personal jurisdiction is, it's discussed on page 86, and it's the power of the court over the person themselves. So if you are, I think one example would be if you are a West Virginia resident and you are traveling and you go to Utah and you end up hanging out there for a little while, and you drive your car out there, and you make some sort of mistake. You drink and drive, or you do something reckless and you get into a car accident. The court of Utah would not technically have personal jurisdiction over you because you are not a resident there, but by virtue of driving your car, we have something that's called long-arm statutes. All the states have a long-arm statute in effect that says if you do something like drive your car and take advantage of the roads and the resources that are in the state, then you are opening yourself up to jurisdiction in that state. So they can use their long-arm statute to pull you into their jurisdiction and have personal jurisdiction over you. Now, let's say that you are in West Virginia and you make a deal with someone that lives in a different state, so maybe Mississippi or something like that, and the person in Mississippi decides that they want to sue you for something that happened during your dealings. Maybe they were visiting West Virginia and got into a fight or something, and they want to sue you for some sort of negligence or something, and they go back to Mississippi and they file a case there, file an action there, and try to sue you in state court in Mississippi for something that happened in West Virginia. The Mississippi court's not going to have personal jurisdiction over you to do that, to pull you into there for something that didn't happen there. In rem jurisdiction is jurisdiction over the thing or over the property. So maybe your issue is dealing with a house or a piece of property that is located in the state of Ohio. Then the courts of Ohio are going to have jurisdiction over that matter because the property is located in that state. Okay, types of law. The main distinction you see is criminal law and civil law. And I have some handouts that will be posted in resources that you can kind of take a look at and look at these distinctions and kind of work through it and make some notes. The main differences are the burden of, who the parties are first. In criminal law, the parties are going to be the government representing society as a whole, and then a citizen on the other side. So if someone commits a murder, or someone commits a robbery, or someone does something that we have decided as a whole, as a society, that we will not allow, then the government can file a case against that person that now becomes the defendant. Civil law is a dispute between two citizens, so whether it be a company or an individual versus individual or an individual versus company, it's where the government's not usually involved. Every once in a while the government can be a defendant in a civil or a party in a civil action, but that's kind of a separate issue. Okay, and one issue to take a look at is burden of proof. In criminal law, the government, the state, the federal government, whoever the governmental unit is, has the duty to prove their charges beyond a reasonable doubt. Not beyond any doubt, but beyond a reasonable doubt. In the civil law, usually the standard is by a preponderance of the evidence, or more likely than not. Sometimes some cases have a heightened standard of clear and convincing evidence. And the unofficial kind of way to think of that is criminal law, the government has to prove, like, if you're kind of looking at odds, 90% likely that the person did it, that beyond a reasonable doubt. And then under civil, preponderance of the evidence, more likely than not, more than 50%. And clear and convincing is closer to like that 70%. So you can see the burden of proof is lower on the civil side. In a criminal law, in criminal case where someone has the potential of having, that they could be incarcerated, they have a right to a jury trial and a right to an attorney. Punishments and remedies are obviously very different in criminal law. Incarceration, probation, any type of thing that restricts the person's liberty is a possible remedy or punishment or result of the verdict. Whereas in civil law, you're usually looking at monetary damages. Sometimes you'll see being forced to hold up your side of a contract, or an injunction to stop what you're doing. There is a right to appeal on both sides, except for a criminal law, the government can't appeal a not guilty verdict, but the defendant obviously can appeal a guilty verdict. In civil law, both parties have a right to appeal, not necessarily a right to hear it, depending on what court and case you're in, but a right to appeal. Substantive law versus procedural law. Substantive law defines and regulates the rights and obligations. It's the law itself. Procedural law is more about the method of how you do it. So all the rules of civil procedure that you'll see are rules of criminal procedure on how long you have to file this or that and what you have to include when you file, that kind of thing, are the procedural law. Types of courts. Generally, you have a trial court, and then an appellate court, and then a Supreme Court, or the highest court. In the federal government, the trial courts are called district courts, and the appellate courts are called circuit courts of appeals, and then we have the U.S. Supreme Court of Appeals. There are multiple district courts all across the country, and the federal government splits everything up geographically, so where you fall. Appellate courts, that intermediate level, we have 13 circuits plus the D.C. circuit, so that's where you would appeal any of your district court cases, and they will take a look at it. They might not necessarily hear it, but they will take a look at it. And then the U.S. Supreme Court has complete discretionary appeal that may or may not look at it. State courts can set up their own system. West Virginia is one of, I just looked this up, it used to be 13, but I think it might even be less now, of state courts that do not have an intermediate appellate court. We have our trial courts, our circuit courts, though we also have magistrate courts and family courts, a municipal court below that, but in terms of the court of general jurisdiction, it is our circuit court. And if you want to appeal a decision of the circuit court, you have to appeal to the West Virginia Supreme Court of Appeals, which is has discretionary appellate power that may or may not hear it. We don't have that intermediate appellate court level that most states and the federal government does. Okay, so pages 92 and 93 in there kind of go over what I just talked about in terms of the Article 3 courts, the district courts, the circuit courts of appeal, and the U.S. Supreme Court. And then there are specialized courts that deal with issues like bankruptcy, etc. In order to file a case, you have to have what is called standing. You have to have a personal stake in the matter at hand. Easy example in West Virginia, if you're driving along I-77 South and there and you go off and you see the mountaintop removal that's taken place and you see how the land has been destroyed and left, you can't just as a citizen say, hey, this is wrong, we shouldn't abuse the environment, and file suit on behalf of the environment. You have to have a personal stake in the matter, so it would have to be like your land or something. There are three different types of opinions. The majority opinion is the law, the rule, the one that is in effect. A concurring opinion is when a justice agrees with the majority or agrees with the outcome, but perhaps has different reasoning on how they got there. So they can file what's called a concurring opinion to explain the reasoning of how they got there. And a dissenting opinion is when they disagree with it. So there in the resources, you can look at the handouts for the court systems there in West Virginia and Ohio. So these are the damages that are available on the civil side. So they are, the first four are all dealing with some sort of monetary compensation. Compensatory damages are those monetary amounts that the person is out. So you have a car wreck and the person has damage to their car, they have medical bills, those are compensatory damages. Punitive damages are meant to punish. So if someone did something really horrific or negligible and we want to make sure that that type of thing does not happen and you want to punish that defendant and discourage anybody else from engaging in it, then punitive damages might be awarded. Nominal damages are those damages that a court can award when there isn't really any compensatory damages, but they did do something wrong, so they might give them something nominal like $1. So you win, and we're going to award nominal damages, so you're not actually getting much money, but you do win. So you have, the victory, but not necessarily any kind of real outcome out of it in terms of money. Liquidated damages, if you have a contract, sometimes parties will put in liquidated damages clauses, so if you don't follow through with your end of the contract, then the contract might specifically say that you have to pay X amount in damages. And then equitable damages are the other ones I was talking about that don't deal with money. Injunctive relief is when someone has to stop doing whatever they're doing. So maybe you do have property and someone is doing something that is damaging your property. The court could grant injunctive relief to make them stop. Declaratory relief is when you have something going on and you want to file with the court and ask them to declare ahead of time that this is right or wrong kind of thing. Specific performance is that performing your contract. You have two parties that have a contract and one decides they don't want to do it anymore. The court can order specific performance and make them do it. Rescission is when you take the contract and say that it's not worth anything, or it's not fair, it's not legal, and you just get rid of it altogether. Reformation is when you have a contract and you want to make the contract so it is valid, so you fix whatever the unfair or unjust portion was. Okay, so that is the PowerPoint, which will also be available. Here is the Sakai site that we're looking at right now. So I will add an announcement, and then under resources, if you click on government resources, here are those that I was talking about. So the West Virginia Circuit, a map of the West Virginia judicial system, a map, a chart of the Ohio court system, etc., that you can kind of look through and make sure that you're familiar with all this information. Under assignments, LE 101, assignment 1 is due here at the end of week 3, so make sure that that is submitted. And assignment 2 is up, and it is an essay, 3 to 5 pages, explaining basically what we just went over, writing to tell someone that doesn't understand and has no knowledge of the American system of government how it works. Tests and quizzes, you should have completed by the end of week 3, chapters 1, 2, 3, and 4 quizzes, and then there's the week 4 quiz that is up. Okay. Westlaw, if you are not on Westlaw yet or don't have the information, then make sure you send me a message. When you first get your password, it will be a 16-digit combination of numbers and letters, and sorry, my internet is a little bit slow here, but if you switch to Westlaw password sign-on, hopefully that'll pop up, and you can, there we go. So you would enter that 16-digit number here, and then in the client ID, just put like your last name. The purpose of the client ID is to track how much time is being spent working on like a specific case. If you were working in a firm, imagine that you had multiple cases and you were going to do research for one of those cases, and you could enter your client ID, and then when they do the report at the end of the month, or whenever they do billing, they would know how much time you spent there. Okay, and then once you have entered that, it will direct you to set up an account to do a 1Pass username, and you can set that up to be whatever you want it to be, and that way you don't have to remember that 16-digit code or have it every time you want to get on. Okay. The first screen you always come to when you come to Westlaw is an agreement. Basically, this is saying that you are just using this for school purposes, that you are not using it to profit, that you're not using it, so say you go get a job working in a law office, you're not using it to do research for them using the subscription. So you're only using it for school purposes. That's what you're agreeing to when you click I agree. And then when Westlaw loads, you can customize this more. I like the directory at the top. That's where I just clicked. And then all databases. And this shows you everything that's here. So you can look around and see kind of what's here. If you want to look at West Virginia materials, then if you click West Virginia is at the top of my list, you can see the cases, the statutes, the court rules, and all the different sources of law we talked about there, and take a look at it. Okay. This is supremecourt.gov. Under resources or links, I think these links are here too. You can go and see like the current cases, the rules. You can go to congress.gov and see current legislation. The West Virginia Judiciary has current opinions and that kind of thing. The U.S. House of Representatives, if you want to go find out who your representative is, and same with the Senate. Okay, I think that is it. If you have any questions, send me a message.